a historic bridge between the past of a deeply divided society and a future founded on the recognition of human rights. That's a direct quote from South Africa's interim constitution, and it absolutely perfectly sets the stakes for our explainer today. Just imagine, for a second, trying to engineer a peaceful, democratic future out of the deeply painful legacy of systemic injustice, and doing it entirely through the sheer force of constitutional law. It's almost hard to wrap your head around, right?
Well, welcome to The Explainer. Today, we're unpacking a literally unprecedented legal judgment. Back in 1996, South Africa's proposed new constitution was, for all intents and purposes, put on trial. We're going to explore exactly how this massive democratic exercise unfolded, the incredibly intense legal battles it sparked, and, of course, the final verdict that ultimately shaped an entire nation.
Okay, let's dive right into this. Here is our docket for today. First, the historic bridge. Second, the solemn pact. Third, the certification test. Fourth, testing the Bill of Rights. And finally, number 5, the final verdict. Section 1. The historic bridge. Now, to truly grasp the weight of this monumental document, we really have to look at the ashes it was forged from. South Africa was in the middle of transitioning from the repressive apartheid system, which was a regime defined by parliamentary supremacy and racial discrimination. The goal? To build an entirely new order, one completely based on constitutional supremacy, universal human rights, and multi-party democracy. But as you might guess, moving a deeply divided country from point A to point B required a ridiculously delicate transition. And a timeline of this transition? It is just staggering. In 1990, confidential talks opened up into formal negotiations. By 1993, an interim constitution was adopted. Then, in 1994, the country saw its first free elections, and a constitutional assembly was formed to draft the final text. By 1996, that final text was submitted to the court. It was just this incredible momentum shift that managed to avoid a cataclysmic deadlock.
Section 2. The Solemn Pact. So you might be wondering, how in the world did opposing sides actually agree to hand over power without knowing what the final constitution would even say? Well, the deadlock was broken by a solemn pact made up of exactly 34 constitutional principles. Think of these principles like an architectural blueprint. The negotiating parties agreed that the final text absolutely had to obey these 34 strict guidelines, which guaranteed things like a multi-party democracy and universally accepted rights. What this did was create a really clever, programmed two-stage transition. Step 1, an interim government rules under an agreed-upon interim constitution. Step 2, a newly democratically elected constitutional assembly drafts the final text, but, and this is key, strictly within the boundaries of those 34 principles. It was an absolutely brilliant compromise that allowed all sides to keep faith with their constituencies while still moving forward.
Section 3. The certification test. So who actually makes sure the newly built house matches the architectural blueprint? That fell to the newly formed Constitutional Court, and their task was, frankly, overwhelming. They had to weigh the entire new text against those 34 principles, all while processing input from 84 private objectors, 5 political parties, and get this, over 2,500 pages of written submissions. This wasn't just a rubber stamp, it was a massive, fully transparent democratic exercise.
And the absolutely crucial point here is that the court had a strictly judicial mandate, not a political one. They had to act as entirely impartial referees. They made it crystal clear from the start, the political wisdom or the merits of the choices made by the assembly, that wasn't up for debate. As long as those choices stayed within the bounds of the 34 principles, the court would approve them.
Section 4. Testing the Bill of Rights.
All right, now for the high drama, the specific, highly charged objections to the new Bill of Rights. One of the biggest objections centered around this legal concept called horizontal application. Now, normally, a constitution protects you from the government. That's a vertical relationship. But horizontal application means the Constitution also prevents your boss, your neighbor, or even a massive corporation from violating your rights. Objectors really pushed back on this, but the court dismissed their fears, basically saying that balancing competing private rights is just a normal, everyday judicial function.
Which brings us to a fiercely debated question. Should employers have a constitutional right to lock out striking workers? Objectors were quick to point out that the new text explicitly gave workers the right to strike, but completely left out the employer's right to a lockout. They argue this was entirely unfair and crippled collective bargaining.
The court evaluated this very neutrally against international norms and came to the conclusion that they aren't actually equivalent. Workers inherently need the right to strike to balance out power dynamics. Employers, on the other hand, already possess other significant economic weapons, like dismissal or hiring replacement labor. So omitting the lockout was totally fine. However, the court did flag that failing to protect the right of individual employers to bargain collectively was a structural flaw that needed fixing. Now, what's really interesting is the debate over who actually gets these rights. Do corporations have human rights? Some objectors argued heavily that granting rights to wealthy, juristic persons, like massive multinational corporations, actually diminishes the rights of everyday, natural human beings. But the court disagreed. They pointed out a very practical reality. In South Africa, there are countless small family businesses and close corporations that need legal protection just as much as individuals do. And think about the media for a second. If juristic persons don't have freedom of speech, the newspapers, broadcasters, and journalists literally can't function effectively. Then, of course, we have property rights. As you can imagine, this was a massive battlefield. Objectors were furious that the text didn't expressly protect the right to acquire property, and that it explicitly allowed expropriation for land reform. The court systematically rejected this objection. They noted that internationally, there is simply no universally accepted single formulation of property rights. The proposed text protected against arbitrary deprivation and required just, equitable compensation decided by a court. For the referees, that meant it was perfectly compliant. Next up was the inclusion of socioeconomic rights. We're talking guarantees for housing, healthcare, food, and water. Objectors raised a very practical, very tough question. Are these rights actually enforceable by a court? Or does including them just mean judges will end up illegally dictating the government's financial budget, completely breaching the separation of powers? The court's logic in responding to this was absolutely fascinating. They pointed out that even traditional civil rights cost the government money. Take the right to a fair trial, for example. That requires the state to pay for courts and legal aid. Therefore, socioeconomic rights don't inherently breach the separation of powers any more than standard civil rights do. Courts can always, at a bare minimum, provide negative protection, meaning they can stop the government from improperly taking those rights away. But listen, the court didn't just rubber stamp the whole document. They found a major, glaring stumbling block regarding states of emergency. The text allowed certain rights to be suspended or derogated during an emergency, but the court found some of the distinctions between what could and couldn't be suspended to be completely inexplicable and arbitrary. For example, the text would have allowed the state to suddenly use improperly obtained evidence in court during an emergency. The court put their foot down and ruled that could never be justified, no way, even in a crisis. It was a clear failure of the test. Section 5. The final verdict. So, after painstakingly weighing 2,500 pages of arguments, it was finally time for the judgment. And the verdict was incredibly nuanced. The court declared the drafted text a truly monumental achievement. However, certification failed because of a few specific technicalities, like omitting individual employer bargaining rights and those arbitrary emergency rules we just talked about. The text did not perfectly align with the Solemn Pact. So the Constitutional Assembly was ordered to go right back to the drawing board and fix it. Now, you might think a rejection is a failure, but this rigorous rejection actually proved the absolute integrity of the entire process. It proved that the court was a true, independent referee, making sure a fractured nation got exactly the democratic foundation it was promised. Which leaves us with this final lingering thought. If a constitution can be successfully engineered and rigorously legally tested to heal a deeply divided nation, could this incredible feat serve as a blueprint for the rest of the world's struggling democracies? Thank you so much for joining us for this explainer, and keep learning.